little man Hughley. Y'all call him DL Hughley?
Damn, don't do that. I like, don't do that. DL Hughley, my guy, don't do that.
Why not?
Don't
I'm talking the truth.
Go ahead, what he said? What he said?
He talking crazy. It's not my fault he's little and he got a complex, you know? And at the end of the day, I told him, I said, look, brother, you feel this type of way about me. Let's go into the ring. Let's box. You know what I mean? I told him, we put up $1 million. Let's box.
Hold on. The man of God can't be talking about let's box.
Why not? The Bible says I'm anointed to lay hands.
Lordy have mercy, y'all. Now, he ain't no bigger than a flea in a wrestling jacket, his own damn self, and he's calling DL Hughley little? Now, y'all know this boy is crazy, so let me just get right into it and stop wasting my time trying to figure this crazy ass man out. Hi there, I'm Professor Blackmore, and welcome back to my channel. And today, I'm coming back to you with chapter 6 in my series entitled The Gospel According to Bishop Whitehead. More specifically, I'm coming back to you today to talk about the bankruptcy case involving the real property associated with the church located where Bishop Whitehead is currently holding his in-person church services. And now for those of you who don't like Bishop Whitehead, you'll get great satisfaction out of this episode, which I strongly feel may be the last chapter in the bankruptcy section of this book, because there have been some interesting developments. Now, in my last update on this case, I informed you that Bishop Whitehead's attorney failed to appear at the March 1st, 2023 hearing, at which time the judge was set to hear arguments on the Glory of God Church and Mr. Moses' motions to dismiss the bankruptcy case. And as a result of his absence, the judge dismissed the case. And you would have thought the matter would have been over at this point. But no, honey child, no indeed, not this crazy mixed up mess. Because Bishop Whitehead's attorney quickly filed this motion, asking the judge to vacate her order dismissing the case. And in this filing, Bishop Whitehead's attorney states, quote, that he failed to properly calendar the initial conference and hearings, that he was consenting to surgery for his mother on March the 1st, 2023, due to burns to 40% of her body, that his mother underwent surgery on March 2nd, 2023 at the University of Florida Hospital in Gainesville, Florida, end quote. And quite frankly, I would lose respect for this guy if he's lying about this, but anyway, y'all. And so, as a result of this excuse for missing the hearing, the judge entered an order scheduling an emergency hearing on the motion to vacate the order of dismissal, setting the matter to be heard virtually online by video appearance on March 9th, 2023. Now, for whatever reason, and I'll talk more about what I thought those reasons were, so you can watch my prior video to get more information about that. But the judge adjourned the March 9th, 2023 hearing and told the parties at that time that she will be setting a further hearing set to take place on March the 30th, 2023. And now thereafter, on March 13th, 2023, the judge entered this scheduling order, setting the hearing to take place in person on October the 3rd, 2023 at 9:30 a.m. The order stated further that, quote, it is further ordered that if the motion to vacate the dismissal is granted, the debtor, i.e. Bishop Whitehead, shall appear on March 30th, 2023 at 9:30 a.m. or as soon as thereafter, as the parties can be heard before the judge and show cause why this case should not be dismissed based on Bishop Whitehead's failure to file monthly operating reports, schedules, attend the creditors meeting, etc. End quote. And so, if the order dismissing the case was vacated, the judge was letting Bishop Whitehead's attorney know that Bishop Whitehead was going to have to appear in court in person and explain why he had not filed all of the required paperwork and done other things that I'll discuss momentarily. Well, you won't believe this, but the March 30th, 2023 hearing did not take place. And the day before the hearing, Bishop Whitehead's attorney filed this motion to withdraw Bishop Whitehead's motion to vacate the judge's order of dismissal. Now, in order to obtain a copy of a transcript of any of these hearings that have been held in this case, you have to make arrangements with the court's transcriptionist and pay him or her their fee before he or she will provide the transcribed record of what occurred in a hearing. And so it was hard to know what all actually happened in that March 1st, 2023 hearing that Bishop Whitehead's attorney missed without having an actual copy of the transcript. And so now, let me back up a few steps. Now, the judge's scheduling order, scheduling the March 30th hearing, further ordered, quote, that the deadline to file and serve written oppositions to the court's motion to dismiss and to Bishop Whitehead's motion to vacate the dismissal was going to be March 17th, 2023. But as you can see here, the only party that filed a written opposition was Glory of God Church. And so I initially found it very odd that Mr. Moses did not file an opposition. And you'll remember that I can't really understand why Mr. Moses was fighting against Bishop Whitehead in the first place, because the only reason Bishop Whitehead filed the bankruptcy was to evict Glory of God from the church premises. And since you can't really be unevicted, Bishop Whitehead has fulfilled his purpose, which can't be reversed by Glory of God because Mr. Moses is the new owner of the church. And so it is remarkable that Mr. Moses did not file anything. But we did get a very interesting tidbit out of Glory of God's filing, and that is Exhibit 3 to their opposition, which is a copy of the transcript from the March 1st, 2023 hearing, which is quite explosive in my opinion, because the judge spoke her mind, honey child. And as you can see here, it is displayed on the court's docket so that all have access to it. And I'm quite sure that Bishop Whitehead's attorney had an opportunity to read it. And I'll tell you one thing, if I were Bishop Whitehead's attorney, I wouldn't have showed up in front of this judge again either, trying to explain why she should vacate her order dismissing this case, because she made her position very clear about how she felt about this case. And it is a hot epistle, honey child. I mean, all I know is it put the fear of God in me, and I ain't even in this case. And so I'm going to read from this transcript of the March 1st hearing that Bishop Whitehead missed, which also reveals some information that I was not aware of about some facts revealed by the court-appointed bankruptcy trustee regarding the creditors meeting, which I told you in part 1 of this series is a very important event in a bankruptcy case. And so the judge says, I don't see an appearance by Bishop Whitehead's counsel. In addition, I didn't see a response to the motion to dismiss filed by Bishop Whitehead's counsel. Then the court-appointed bankruptcy trustee says, we held a meeting of creditors in this case on the 24th of February, and Your Honor, no representative of Bishop Whitehead appeared. The United States trustee adjourned the meeting to the 14th of April, the holding date, pending the ruling of today's motion. Then the judge says, I was going to take a minute and just put something into the record just to kind of close the loop just to make sure that if Bishop Whitehead decides to, to come back, that there's something in the record that tells him why the motion to dismiss were granted. And that way, if Bishop Whitehead wants to appeal, that's fine. I'll make a motion for reconsideration, although I don't think that's likely. Now, the judge goes into trying to establish whether there is a business purpose. And because Bishop Whitehead never filed a response and was not present at the hearing, she reads information on file provided by Glory of God and Mr. Moses, and she states, quote, Bishop Whitehead also stated the debtor leased its property to Leaders of Tomorrow International Ministries, and that's the entity that operates the church in a community center at those premises. So, even though the debtor leases the property, the fact that he doesn't have employees or bank accounts or other assets is a further indication that the debtor does not operate a business, is not a business trust, and does not operate to generate a profit, end quote. And again, based on the fact that Bishop Whitehead never filed a response, putting these issues into the record, letting the judge know that maybe he does have bank accounts, maybe he is operating a business, i.e. the church, and other things that would establish that this is a business bankruptcy, then that is what the judge is doing at this point. She's taking the information that is on the record and from the arguments of the people that are before her in the hearing. Then she says, for these reasons, this debtor is ineligible to file for bankruptcy, and if he files again after I put something on the record saying that they're ineligible, then then there's the risk that there's sanctions against whoever files that petition, and we'll take it from there. I hope you heard that, Bishop Whitehead. Then the judge states further, quote, it is clear that Bishop Whitehead, who signed the petition, did not have authority to put this entity into bankruptcy, and this case was filed without authority, and I find that Glory of God's motion to dismiss and Michael Moses' motion to dismiss should be granted, end quote. Okay, and then this will answer the question of why Mr. Moses did not file an opposition to the motion to vacate the dismissal by the March 17, 2023 deadline that I was talking about earlier. And that is because the judge states further, quote, I'm only going to enter one order dismissing the case, so I'll grant Glory of God's motion. And then the judge says again, they're ineligible to file, and if they try to file again, then that's a problem for them. She was making it clear, honey child. And so, at this point, she has had it with Bishop Whitehead and his shenanigans. And in my opinion, he's treading on thin ice at this point. But since Bishop Whitehead's attorney was not present at this hearing and not having access to the transcript or what the judge said, you'll remember from my prior review of this case that Bishop Whitehead's attorney had already refiled the bankruptcy of this case on March 3rd, 2023 under a brand new case number. And this is the docket sheet for the new case, and this particular bankruptcy case remains open at this very moment. But after reading that frightening transcript of what the judge had to say at the March 1st, 2023 hearing, and because this would be, I surmise, Bishop Whitehead's first opportunity to actually see what the judge actually said, I am assuming that Bishop Whitehead's attorney thought that the best thing to do was to let this sleeping dog lie and get the hell out of this mess. Because again, the purpose for filing the bankruptcy, which was to have enough time and space to effectively evict Glory of God from the church premises, has been served by the bankruptcy. And at this point, Glory of God has no standing to now try to evict Bishop Whitehead from the church. And so if you ask me, now that the court-appointed bankruptcy trustee has revealed that Bishop Whitehead's attorney did not file the required paperwork in advance of the creditors' meeting, and that he did not attend the creditors' meeting, and after learning that he did not even file a response to the motion to dismiss, I will say that I probably don't believe that excuse that the attorney gave about his mother being hospitalized, because it seems clear to me that he never intended to appear at the March 1st, 2023 hearing in the first place. Because if an attorney intends to appear at a hearing, they will absolutely file the required written responsive arguments, which he did not do in advance of the deadline. And so, with all of this in mind, and all of this heat coming from this judge, Bishop Whitehead's attorney filed the motion to withdraw his request that the judge vacate her order of dismissal of the first bankruptcy case the day before the March 30th hearing. And on March 30th, he turns around and he filed this motion to dismiss the second bankruptcy case, in which he states, quote, BT Trust disclaims or denies any debt against the estate, which was clearly a phony reason for filing either of these bankruptcies in the first place. But I ain't mad at them, because it did the trick of evicting Glory of God from the church premises. And so, Bishop Whitehead's attorney further states in his motion to dismiss the bankruptcy case that cause exists, this phony cause, this phony reason that he picks out of the clear blue sky. This is cause, an appropriate circumstance justifying dismissal. He states further that Bishop Whitehead will resolve any issues with the former property squatters, i.e. Glory of God Church, in a New York State court, which I don't think they have any intention of doing. And I know y'all believe that. Now he states further, therefore, Bishop Whitehead requests that this Chapter 11 case be ordered dismissed, end quote. And the court issued an order scheduling a hearing on Bishop Whitehead's motion to dismiss the bankruptcy case, set to take place online on April the 5th, 2023. And so, I guess this mess is finally over. Or is it? But let's recap, because you'll remember that Mr. Moses, through the 5904 Foster Avenue Trust, acquired the church property all the way back on January the 27th, 2022 in a foreclosure sale, which means that Glory of God Church had not been paying the mortgage prior to that time. They just wanted to occupy the church without having to pay the mortgage, allegedly. And so, after 2 months of not being able to evict Glory of God Church, on March 9th, 2022, Mr. Moses entered into a series of agreements, resulting in that March 9th, 2022, 5904 Foster Avenue Trust Addendum appointing Bishop Whitehead as trustee to take legal action at his own expense to evict Glory of God, which also included some type of lease to purchase agreement in which Mr. Moses leased the property to Bishop Whitehead. And so, it was not until Bishop Whitehead filed the initial federal court filing that he filed on December the 19th, 2022, and the subsequent January 24th, 2023 bankruptcy filings that gave him enough time and space to evict Glory of God from the church, because the New York courts were not helping at all and were perfectly all right allowing people to live rent-free in other people's property. But as y'all know on here, I just ask and report, and I let you decide. So, what do you think now that this mess seems to be finally over? Will you agree that this was, if the truth be told, a pretty crafty technique to evict Glory of God from the church, when it was clear that the New York court was perfectly fine allowing them to remain as occupants on property that Mr. Moses purchased almost a year prior? Please let me know by leaving your comments in the comments section below. Although I already know what y'all gonna say, because y'all just cannot stand this dude. But please let me know what you think anyway. And I hope you'll also give me a big thumbs up. And I hope you'll also consider donating to my entire channel ministry by clicking the super thanks heart button below, or by donating to the Professor Blackmore Cash App. And while you're there, I hope you'll also subscribe to my YouTube channel and click the bell so you'll be notified whenever I come back with more hot tea on this case. And please also follow me on TikTok and Instagram.